11 years. She operated for 11 years before anyone assembled the full record. I want you to sit with that number, not as a statistic, but as a span of time during which elderly women who were grieving and alone handed over money they could not recover in exchange for a protection that did not exist, manufactured by a person who had learned to read their pain the way a locksmith reads a lock. I have been in courtrooms for 22 years. I have sat in 3 different chairs in this building, as a defender, as a prosecutor, and as the judge at the end of the table. I have watched people cause harm in almost every configuration the human imagination has devised. But there is a specific quality to this kind of case, the kind where what was stolen was not only money, the kind where the instrument of the theft was care, was warmth, was presence, was the specific intimacy of knowing someone's grief better than their own children did. My name is Catherine Merrill, and what I am about to tell you is how I know that, because the record told me, and the record does not lie, even when the person who built the operation believed it would. This is a hard case to hear, I know that. If someone you loved was ever in a room like the ones I am going to describe, if someone with a practiced manner and the right words ever found the space that grief opens, I want to hear what you found most difficult about what happened. Write it in the comments. I read every one. When you lose track of what justice actually looks like, subscribe to this channel, hit the bell, come back here. Because what happened in my courtroom begins with something she believed would protect her. She had them sign a contract. I want you to understand that before I tell you anything else about this case, before I describe the courtroom, before I describe the defendant, before I describe the women who sat in the gallery on the day I delivered my ruling. I want you to understand that she had them sign a contract. She had thought about this. She had considered the possibility that someone at some point might ask questions, and her answer to that possibility was a document, a piece of paper that she believed, with the particular confidence of someone who has never been seriously challenged, would make her untouchable. I held that contract in my hands on the morning the case came before me. I read it in my chambers before the session opened. It was 2 pages, single-spaced. It used words like voluntary and freely chosen and non-refundable. It described the defendant's services as spiritual consultation and guidance, and it included, and I want you to hear this carefully, a clause requiring the client to hold the defendant harmless for any outcome, spiritual or material. I read that clause twice. And then I set the contract down on my desk and I sat with it for a moment, because that clause told me something important. Not about what the defendant was doing. I already understood broadly what the defendant was doing. What that clause told me was what she was afraid of. You do not write a harmless clause in a spiritual consultation contract unless you know, somewhere in the specific knowledge of what you are building, exactly what you might be held responsible for. That was the morning before the session opened. By the time the defendant walked into my courtroom, I already knew something about her that she did not know I knew. And that, in my experience, is the most important moment in any proceeding. She walked in the way people walk in when they are not frightened. I have been in this building for 22 years, and I have watched more people walk into this room than I can count, and the walk tells you something every time. Not what you will find in the record, but how the person understands the situation they are in. She walked in ahead of her attorney. She was dressed carefully, not expensively, carefully. There is a difference. Expensive says, I have resources. Careful says, I have considered how this room sees me. She had considered how this room would see her, and what she had decided was that warmth was her best tool. She smiled at the clerk. She nodded at the bailiff. She did not look at the women seated in the gallery. There were 4 of them. The youngest was 71. The oldest was 81 years old, and she had driven herself to the courthouse, and she sat with her hands in her lap, and she did not move for the duration of the proceeding. I noticed her when I entered. I notice most people in my gallery. It is the habit of 22 years. But I noticed her specifically because of the quality of her stillness. It was not the stillness of someone who is frightened or uncertain. It was the stillness of someone who has made a decision, who has decided that they are going to be present for this fully, and that nothing in the room is going to move them from that position. I have seen that quality of stillness before. I spent 9 years as a public defender in this county, and I sat across tables from clients at 7 in the morning before proceedings I was not sure I could win, and some of them had that same stillness. The stillness of someone who has already paid the highest price and is now simply here for the accounting. I want to tell you what I had learned about this defendant before the session opened, because it is the kind of thing the record does not always capture in a way that communicates its full weight. She had been operating for 11 years. 11 years in a storefront in a commercial district, appointments by referral only, a cultivated reputation in a specific community, the community of people who are grieving and isolated and looking for someone to tell them that what they are feeling is not permanent, that the people they have lost are not entirely gone. This is not a small community. This is not a community of people who are unintelligent or credulous in some unusual way. Grief is a specific condition. It does the specific thing of making the world feel unreliable. And when the world feels unreliable, people look for something to hold. The defendant had spent 11 years presenting herself as something to hold. Her intake process, I want to describe this because it matters, was a form, a questionnaire that new clients completed before their first appointment. The form asked about health. It asked about recent losses. It asked about fears. It asked specifically whether the client had experienced any unusual events since a loss, dreams, sensations, sounds. I read this form and I knew immediately what it was. It was inventory. It was a map of the specific vulnerabilities of the person sitting across the table, assembled under the appearance of pastoral care, before a single session had occurred and before a single dollar had changed hands. She was not learning about her clients so she could help them. She was learning about her clients so she knew where to press. What happened over the weeks and months that followed the intake form was a relationship. I want to be precise about that word, a real relationship. Not a simulation of one, not a performance of one, but an actual human connection in which these women felt genuinely known, genuinely cared for, genuinely accompanied through the hardest years of their lives. I am not saying this to complicate the record. I am saying it because it is true, and because understanding what the defendant was doing requires understanding that what she built was real. The intimacy was real, the comfort was real, the love these women felt for her was real, and she used every bit of it. The mechanism, once the relationship was established, worked like this. The defendant would introduce, during a session, a new spiritual emergency, a curse threatening the client's family, a darkness gathering around the late husband's soul, a danger that required immediate action and always an immediate payment. The urgency was manufactured, the emergency was manufactured, the darkness was manufactured, but the fear that followed was not. The fear was entirely real because it was attached to the most real thing in the client's life, the person they had lost and continued to love. The financial records told this story with a precision that the defendant had never anticipated anyone would read. Every major payment, and I mean every one, had been made within 48 hours of a session in which a new emergency had been introduced. Every one. The pattern was as regular as a billing cycle. I looked at those records and I thought of something I had learned in 9 years as a public defender. The pattern is always more honest than the transaction. The defendant's attorney argued that each payment was a separate, freely chosen act. He was a careful attorney. He made the argument carefully. But the argument required the court to look at each transaction in isolation, disconnected from the relationship that produced it, disconnected from the manufactured urgency that preceded it, disconnected from the pattern that connected them all. And that is not how evidence works. Evidence is a record, and a record is read in full. And when I read this record in full, what I saw was not a series of voluntary commercial transactions. What I saw was a system She had built a system. The first witness called by the prosecution was a woman I will call by her initials only, ML. She was 74 years old. She had been a client of the defendant's for 4 years. She had paid, across those 4 years, $31,000. She sat in the witness stand with her hands flat on the rail, and she gave her account with a precision that I found extraordinary. Specific amounts, specific dates, specific words the defendant had used to describe each emergency she had manufactured. She was not reading from notes. She had memorized it. She had spent the years since she understood what had happened to her, going over it in her own mind, and she had the full account ready when the time came to give it. The defendant's attorney cross-examined her. I watched him work, and I want to tell you what I was watching, because I have been on both sides of a cross-examination, and what I was watching was a specific strategy that I recognized immediately. He was not probing the account for inconsistencies. He was probing the witness for fragility. He questioned her memory. He questioned her state of mind at the time of the payments. He asked about her grief, whether it had impaired her judgment, whether she had been able to make clear decisions in the period following her husband's death. The questions were professionally phrased. They were also, in their cumulative effect, designed to use this woman's grief against her, to suggest that the very pain that had made her vulnerable to the defendant now made her account unreliable. I have seen this strategy from the defense chair. I sat in that chair for 9 years in this building, and I know where the legitimate impeachment of a witness ends and where the weaponization of that witness's pain begins. The line is not subtle. It does not move depending on which side of the table you are sitting on. I saw the line crossed in this cross-examination, and I intervened with the specific grounds and the specific language that the record required. ML finished her testimony. Her account stood. The second witness was 81 years old. She is the woman I saw in the gallery with her hands in her lap, still, decided. When she took the stand, she sat with the same quality of stillness she had brought into the room. She did not cry. She had clearly at some point made a decision about that. She gave her account. 3 years, $47,000, a late husband whose soul she had been told was in danger, instructions from the defendant never to discuss the spiritual work with her family because it would break the protection. She said that last part without expression. She said it the way you say something that has cost you a great deal to understand, the instruction not to tell her children. The specific mechanism by which the defendant had ensured her isolation, named plainly, on the record, by a woman who had spent 3 years honoring that instruction and was done honoring it. What I understood from those 2 accounts was something the intake form had already suggested and the financial records had already confirmed, but that required a human being sitting in front of me to make fully real. The defendant had not simply stolen money. She had stolen the one thing these women could not afford to lose, the private interior space of their grief. She had entered that space as a companion, and she had used it as a vault. Then the defendant took the stand. She was confident. That was the first thing I noted. Not the confidence of someone who is innocent. I have seen that, and it has a particular quality of openness to it. This was the confidence of someone who has a prepared account and believes the account is sufficient. She spoke about her work with warmth. She used her clients' names. She described what she did as a calling, as service, as something she had been doing since she was a young woman because she genuinely believed she could help people who were suffering. She was good at this. I want to say that plainly. She was good at presenting herself as someone whose motives were uncomplicated and sincere. And then the prosecution produced an email. The email had been sent by the defendant to one of her clients, a woman she had met once at a community event, 2 days after that woman's husband had died. The email predated any formal appointment. It predated any intake form. It predated any session. In the email, the defendant described, in specific terms, the spiritual danger she believed the late husband was in. She described what would happen to the family if this danger went unaddressed. She provided an appointment time. She provided a fee. The defendant had not remembered this email existed. I watched her read it. She read it the way people read something they are hoping, in the act of reading, will turn out to be different from what they remembered. Then she looked up, and I saw, for the first and only time in that proceeding, something in her face that was not the prepared account. It was brief, 2 seconds, perhaps 3, and then it was gone, replaced by a version of confusion that she had assembled on short notice. But I had seen the 2 seconds, and the 2 seconds were the truth. The email entered the record. What it proved was not simply that she had solicited a grieving woman before any relationship had been established. What it proved was what preceded the relationship, what she had seen before the intake form, before the first session, before the first payment. She had seen a woman in acute grief, and she had known immediately what that meant for her practice. She had moved before the woman had time to find her footing. That is what the email showed. That is the document that began this case and ends this case, the document she had believed was gone. I delivered my ruling on the afternoon of the 3rd day. I want to tell you what it cost to say what I said in that room. Not because it was a difficult ruling, it was not. The record was clear, the evidence was overwhelming, and the law applied without ambiguity. What made it difficult was something else. The defendant was sitting in front of me, and she was a person who had spent 11 years building something that was real in ways that the fraud conviction does not fully capture and cannot fully erase. The relationships were real. The comfort she had given was real. The women in that gallery had genuinely loved her. That is what makes this kind of fraud different from other kinds. The money can be accounted for. The breach of trust cannot be repaired by any instrument this court possesses. I said that in my ruling. I said it plainly. I said, what you took from these women was not primarily financial, and this court is aware that no sentence addresses the full weight of what was lost. And then I delivered the sentence. She had a system. She had a script. She had a contract. She believed that was enough. It was not. 11 years of operation, 4 victims named in this proceeding, a fine and a sentence of restitution that requires her to account financially for every dollar the record could trace, a prohibition from operating in any capacity that involves spiritual or emotional counseling for compensation, and a permanent record, which is the thing I want to dwell on for a moment, because it is the thing courts can provide that nothing else can. The permanent record does not restore what was taken. It does not give back the years these women spent in a manufactured emergency, the money that cannot be recovered, the trust that cannot be rebuilt. What it does is state clearly and irrevocably what was done. It names it. It puts the name on record so that anyone who encounters it will know what they are looking at. She did not speak when I finished. She looked at the table in front of her with the particular attention of someone who has heard something they did not expect to hear. Not the sentence itself, perhaps, but the absence in my voice of any invitation to negotiate. Courts are places where people sometimes believe, even at the end, that there is still a conversation to be had. There was no conversation. There was only the record, and the record was done. I have been on this bench for 9 years. Before that, I spent 4 years as a prosecutor in this county, and before that, I spent 9 years as a public defender in this building. 22 years in total, sitting in 3 different chairs in the same room. And I want to tell you what this case gave me, what it added to 22 years of understanding how that room works. It gave me the image of the 81-year-old woman walking back from the witness stand, the same stillness she had carried into the room. She walked past the defendant's table without looking at it. She sat down in the gallery. She put her hands back in her lap. And for the first time since I had entered the room that morning, I saw her exhale. That exhale. That is what this court was for. Not the sentence, not the restitution, that exhale. The specific physical release of a woman who has been carrying something for 3 years and has finally, in this room, been permitted to set it down. I carry that. What I am committing to, in this room, on this record, and in every proceeding I enter, is reading the pattern. Not just the individual transaction, the pattern. Because the person who builds a system like this one knows that any single transaction can be explained. The intake form can be explained. The payment can be explained. The emergency can be explained. Each piece of it in isolation is defensible. What she did not account for was a court that would read the whole record, a court that would look at 11 years of intake forms and payments and manufactured emergencies and see what they were when you put them together. She had built her operation to defeat the transaction-by-transaction examination. She had not built it to survive the full record. The full record is what courts are for. I want to ask you something. Someone you love, a parent, a grandparent, a friend who was older and alone and carrying a grief they did not always show you. Has someone like this been in their life? Someone with a practiced manner of care, who knew the right words, who was present in a way that you were perhaps not able to be. I am not asking you to feel guilty about that. I am asking you to look at it, because the space this defendant entered was a real space, a space created by real loss and real isolation and real love. And understanding how she used it is the only protection that actually works. Write it in the comments. Whatever you saw, whatever you recognized in this case, I read every single one, and I want to know what you carry out of this room. If what you heard today felt like something you have been waiting to hear said plainly, the mechanism named, the pattern read aloud, the record stated without softening, I would be glad to have you here on this channel. Subscribe and hit the bell. I spent 9 years defending people in that room, 4 years prosecuting cases in that room, and 9 years deciding what the record requires. What I bring here is the same thing I bring to that bench, the full account, from every chair I have occupied, with as much precision as I can give it. The 81-year-old woman drove herself home that afternoon. I do not know what she thought about on the way. I know what she left in that courtroom. 3 years of a manufactured emergency, a silence she had been instructed to keep, and $47,000 that the record now acknowledges by name. Some of what she left there cannot be returned. The record says what was taken. That is what I had to give her. I gave it without reservation, and I would give it again.